Good afternoon, everyone, and thank you for joining us at the first CIPHER Seminar Series. I'm Anisha Koshy, Associate for Public Policy here at DSCI, and will be moderating the event today. Some quick housekeeping rules before we begin. Audience, please mute yourself during the course of the discussion. However, we encourage you to send in your questions via the chat function during the conversation, and we shall pick them up at the end during the Q&A session. In order to leverage the key takeaways from the discussion, we would also like to quickly flag that the session is recorded. Now, before we get into the details of the discussion, let me quickly introduce the CIPHER Initiative to those who might not be familiar. CIPHER is a collaboration between DSCI and Ashoka University and is a fast-growing coalition of institutions and individuals that are using cryptographic and other technical interventions to preserve and promote privacy best practices and leveraging digital trust in India. And the CIPHER Seminar Series is conceptualized as a series of discussions that aim to study the broader conversations around encryption, privacy, and the intersection between everything technology and public policy. All right, now that everybody's filled in, let me introduce our topic of discussion for the evening, Data Protection Bill 2021, what it means for encryption and privacy-enhancing technologies in India. Our speakers for the evening are the esteemed Mr. Nikhil Narendran and Mr. Nitin Dhavate. Nikhil is a partner at Trilegal and has substantial experience in advising companies on telecom, media, and technology laws in relation to India entry, operations, strategy, policy, regulatory issues, disputes, and business models. He focuses on telecom and satellite regulation, data protection, information technology laws, cybersecurity, intellectual property rights, and outsourcing. He has significant expertise in domestic, cross-border, and global commercial contract negotiations, including in relation to strategic M&As, outsourcing, licensing, telecom, cloud, technology, media, and fintech. Nikhil has deep sectoral knowledge of the TMT and fintech spaces, advises regularly on the interfaces between cutting-edge technologies and the laws, and helps in business model structuring. Nitin is a privacy and security leader with a focus on planning, implementing, and maintaining privacy programs to enable business growth while managing privacy risks. He is currently the Data Privacy Officer at Novartis in India, South Asia, and Sub-Saharan Africa, across all the business functions and units. He also works in global initiatives for Novartis. He believes in taking a pragmatic approach to enable responsible innovation while respecting the privacy of the individual and building trust. He also works towards implementing accountability measures at various levels across the organization. Welcome, speakers, and thank you for joining us this evening. I will now request Nikhil to give his opening remarks.
Thank you, Anisha. Thanks for that intro, and thanks for having me here. It's a pleasure, and it's always fun to do a deep dive into some of these topics and specifically discuss the privacy-enhancing technologies that's forming as a feature of the data protection bill. So I would like to specifically, when we talk about privacy-enhancing technologies, so definitely there's a focus on encryption. Encryption is a key part of any privacy-enhancing technology that's been implemented to protect the privacy of the data subject, or what we call in the data protection bill as a data principle. So a few things I want to specifically highlight on is apart from encryption, there are a few other things that the bill talks about. And I think one of the key aspects that the bill seems to be talking about, which will have a major play in protecting the privacy of individuals, is about the consent managers under the data protection bill. So I think one of the if you look at how consent managers have been defined under the bill, it's mentioned as a data fiduciary which is actually engaged in the service of managing consent per se. But it just says that, look, it's just playing the role of enabling a data principle to give, withdraw, review, and manage the consent on an accessible, transparent, and interoperable platform. So I want to first talk about consent managers first, and then move on to some of the other privacy-enhancing technologies. That's the finding I mentioned in the data protection bill. So consent managers, for instance, I believe is going to be quite significant because, as you know, the data protection bill is very focused on the principle of consent per se. And there are a few exceptions given to consent under the bill for management. And typically, when you have so much of consent regime governing a data protection framework, typically consent fatigue happens, and consent really loses its meaning. And that's where I think consent manager is going to play a significant part. And it's been something that many have pointed out that, look, if you have a bill which is focused on consent so much, then ultimately you will eventually end up eroding the value of consent itself. But I personally believe that consent is really the bedrock of our civilization. So whether it comes to, using a royal franchise to elect a government, whether it's interpersonal relationships, for that matter, consent is fairly a very significant concept, even philosophically, legally, currently in our civilization. And to that extent, I think the bill goes along recognizing consent managers. And the way I think it'll eventually come up will be based on the DAPA framework that's been presented and that's been used in several other tools that we see around us. For instance, the account aggregator framework that's currently gone live. So I think the way in which it should work is basically that there will be these third-party operators which will be licensed or given a license by the Data Protection Authority, and these third-party operators will help us give consent and transfer data, and for that matter, help the data subject exercise their right to give information, withdraw consent with respect to that information, request for aspects like right to erasure, correction, etc., which I believe is a great privacy enhancing technology that the bill is actually putting forward. Now, there are a few aspects with respect to the actual role that will be played by the consent manager in this whole arrangement. So I think one key aspect there will actually be the fact that, or should be the fact that, it should be some sort of a data blind fiduciary, which should not have access to the actual data that's being transferred from one party to the other. For instance, when you look at a typical function like porting your data from one social media platform to another social media platform, one key interesting aspect here should be that the consent manager should not have ability to look into the actual data that's being transferred from one platform to the other. So to that sense, data blindness should be a very important privacy enhancing technology that should be a feature of consent manager. The second and the most important factor that should be relevant here is what should be the commercials around which the consent managers should actually be operating around. Typically, we've seen that intermediaries or players who play a role in between should one have a real commercial objective in sort of doing that, and we should let the market sort of evolve and create frameworks surrounding that. So there will definitely be data analysis that will be performed. There will be value-added services that will be provided by the consent manager framework per se. So any sort of regulation which should come out around consent managers should facilitate creation of an open market, and we should let the market play out and figure out where that industry will sort of evolve and move. The second aspect I want to talk about specifically is actually on anonymization, which the bill mentions very in passing for that matter. And it talks about an irreversible technology that's prescribed by the DPA. It's sort of prescriptive to that extent. And to that extent, there are concerns from the industry that, look, if you want to anonymize the data, there's no certainty that anonymization can always be or perpetually be irreversible for that matter. And it's possible that, look, with the evolution of technology per se, you will essentially see a data which is once anonymized is possible to be de-anonymized using other technologies such as layering or using data lakes and containers, putting some new containers onto a data lake and sort of try and retagging some of this information you could possibly analyze and find to whom the personal information belongs to. So I think to that extent, I think the bill sort of extends a very extensive framework which sort of keep or ensures or requires the data fiduciaries to really on their toes to ensure that if they're really anonymizing that information, they should keep on enhancing the privacy enhancing technologies that they use or come out with to actually do the anonymization in the first place, which is debatable whether it's the most ideal approach to deal with anonymization technologies. But there are several ways in which this could be achieved, which can be discussed in detail per se. And the last technology that I want to specifically talk about is actually on pseudonymization per se, and the way in which the bill talks about de-identification as a privacy enhancing measure. And de-identification as a measure, if you look at it, and this is something that a sort of a doubt or a clarification that we get from clients all the time. Will de-identification completely eliminate the applicability of some of the aspects in the bill to their operations? For instance, it's very standard to use pseudonymization techniques and de-identification techniques to get out can I get out of the bill if I use de-identification or pseudonymization techniques? The bill actually doesn't do that. What it proposes is that it proposes a framework whereby you use de-identification technology as a privacy enhancing measure, but you still continue to remain responsible as a data fiduciary to comply with your obligations, and you ensure that you use this technology, but still pretty much all the obligations with respect to the bill holds true. But it's just added on as a privacy enhancing feature per se that you should implement as a best practice. You should implement, whether by way of privacy by design standards or by when you outsource your operations to someone else, so that the access to the information is given to only those who are really in need to know that information per se. So I'll pause here, Anisha, and move on to the next round where we can take specific questions on this.
All right. Thank you, Nikhil. We now move on to Mr. Nitin for his opening remarks.
Yeah, thanks, Anish, and thanks, Nikhil, for sharing your views. Thanks, DSCI, for having me. It's always a pleasure to be in such forums. So I'll actually try to cover two key things. I think Nikhil covered them to a certain extent. I'll try to maybe expand on those. So the first thing I'll talk about is what are PETs, I mean, privacy enhancing technologies, what do they really mean, right? And I'll try to talk about them in simple terms. We'll briefly touch upon what are the PETs, both what the data protection bill refers to, as well as some other PETs which don't figure directly in the bill, but do play a role when it comes to enhancing the privacy of the individuals. And then we'll talk about maybe a couple of sections where again it is not called out directly from a PET perspective, but then they do play a role or can play a role over there as well, right? So those are the two things I'll talk about in the next few minutes. I will look at PETs from the perspective of two entities, right? Two key players in this. One is the individual. I mean, we call them data subjects, data principal in the Indian parlance, and the organization who is going to collect this data. Now, the organization may be the government or it may be a private player, whatever the case is. So, from the individual's perspective, what the individual would expect when his or her data is collected is that that data is used in a responsible manner. They will have control over the data to a great extent, and that data will be safeguarded. So these are some of the very basic expectations which an individual would have. On the other side, when the data is collected by these organizations, the organizations want to be in compliance with the data protection laws. And at the same time, they do want to maintain the privacy and the trust of the individual who has shared the data with them, right? So from the way I look at it, typically, anything which allows us to adhere to these requirements, both from the individual's perspective and from the organization's perspective, right, essentially help protect the privacy of the individual, is something that I would call as a pet. And Nikhil gave some great examples, right? I mean, one is the consent manager. If you look at it, it does allow the individual to have control over his or her information. They essentially will be able to control when the data is transferred, what part of the data is transferred, how long it is transferred for, and so on and so forth. So that's the control part of it. It does make sure that the organization who is handling the data manages the data in a responsible manner. They safeguard it, right? Nikhil talked about some other pets like encryption, de-identification via anonymization or pseudonymization. But I think there are other technologies also. So what I will do is I've got a couple of slides just to give a view into some of these pets which can play a role. And as Nikhil already called out, 2 or 3 of them are directly called out in the bill, but there are others which I think can make a difference as well. So I'm just trying to share my screen now. Is my screen visible?
Yes.
Yes, Nitin. Can you put it on slideshow mode? Yes, now it is. Yeah. Please go ahead.
Okay. Yeah, so these are the technologies which I can think of. I think encryption we talked about. We are all aware about asymmetric and symmetric encryption, which has been there for around, I would say, around 40-50 years now. quite a mature kind of technology and widely used, right? There is this new or fairly new, I would say, encryption technology which is coming up, homomorphic encryption as it is called as. And while symmetric and asymmetric encryption have their role to play when it comes to securing data at rest and in transit, there is always this challenge that whenever data actually needs to be processed either by the organization or by a third party on their behalf, the data needs to be decrypted and then processed, right? So that's one of the key challenges that we have been having, and that's where the risk of data getting misused or lost or misplaced comes in. Homomorphic encryption, the beauty of it is that it allows data to be processed even while it remains encrypted, right? So you encrypt the data, you share it with the third party. The third party has no idea what the data actually is, but they can still carry out certain processing activities on that data and then send the results back, which are again encrypted. And the organization who has sent the data can decrypt that and make sense out of it, right? So it's kind of the holy grail of processing, if you really ask me, because you are able to share data without apprehension about misuse or loss of that data by a third party especially, and still get the results that you want in most of the cases. I think Nikhil talked about anonymization, so I'll skip that for the time being. But there are other aspects like differential privacy as an example. It is being used by some of the large entities when it comes to protecting the privacy of data, especially when large data sets are to be analyzed statistically. Data is to be made available publicly. Differential privacy is being used. So a lot of the governments, when they release census data, for example, and allow public to kind of query that data, they use differential privacy to ensure that any individual's privacy is not put at risk, right? So that's one of the key advantages of differential privacy. And differential privacy can give you kind of mathematical guarantees that the privacy is not infringed upon as such, right? There are secure multi-party compute technologies which can ensure that data is split across multiple parties. Each of the parties works on their individual data which they get, send the results back to the main organization, and the main organization can kind of collate all this data and again have the result, right? So no one party, third party has access to all the data, which kind of enhances the security of that to a certain extent at least. Federated learning is where data doesn't go to a central place. This is especially used in AI and ML systems. Data doesn't essentially go to a central place, but actually the AI or the ML model goes to where the data is, right? So if there are 5 parties which have this data and that needs to be used for a learning algorithm, then the algorithm goes to these 5 organizations. The learning happens locally over there, so the data really never leaves the organization as such, right? So these are various pets. As I said, encryption and anonymization do find a direct reference in the data protection bill. But other technologies which are out there do help enhance the privacy of the individual, and the data protection bill would not really oppose use of these kind of pets as well. The others is basically frameworks, and the reason I put that as frameworks is one which Nikhil talked about the consent management framework, which is based on the DEPA architecture, which is going to be used to manage consents. But there can be other frameworks, for example, tools which will help comply with other privacy principles, such as, for example, purpose limitation, right? So data can be tagged with certain purposes for which it can be used when it is collected, and based on the consent which is given by the individual. And if there is an attempt to use the data, for example, for another purpose, then there can be a flag which is raised, for example, right? So these are still evolving kind of frameworks which would definitely help compliance with the data protection bill. Uh, Children's age verification, right? The data protection bill talks about age verification for children, consent from them when they start coming to be of age, for example, in terms of attaining the age of majority, then they need to reconsent, right? So there can be frameworks developed which can help again manage that consent, and again help enhance the privacy of those individuals as well, right? So these are some of the technologies which I thought I can share with you. The other thing which I wanted to briefly talk about is in terms of where these find reference in the data protection bill itself. And I started looking at the data protection bill with some kind of an, I would say, PET lens, if I can call it that. And in the preamble itself, I could find several places where, again, there is maybe not direct reference, but where pets can or will play a key role, right? So for example, it talks about digital privacy. We know that almost the entire digital economy online is powered by encryption, right? We have encryption, both symmetric and asymmetric, being used to power the digital economy. It talks about trust between persons and entities. Again, the trust is or can be gained by responsible use of data, ensuring confidentiality. And again, the encryption and the pets would be the underlying bedrock on which this can be done as well. Technical measures, I think we already know there is direct reference to pets over there. Then we have social media platforms where there is end-to-end encryption used. There is this talk about enabling traceability to who sent the original message because of various reasons. Cross-border transfers are kind of the talk of the town right now because of the Schrems 2 decision. Pets, again, kind of can be one of the ways, encryption especially, one of the ways in which cross-border transfers can be enabled. There is security of the state, which talks about access to potentially confidential and encrypted data whenever there is a need. So there are, I think, several areas where there is reference to pets directly or indirectly, I would say. And when it comes to section-wise kind of representation of these pets, Section 24 about security safeguards is fairly straightforward. So is the codes of practice, because they talk about these encryption and de-identification as identified pets which can be used. But other areas, for example, in Section 9, which talks about retention of personal data and eventual disposal of data when that data is no longer required. And one of the ways in which data can be securely destroyed is to encrypt the data, which is again using a pet, and then securely destroying the key. So essentially you're destroying the data, making it unreadable in the future because you don't have the key anymore as well, right? Reporting of data breaches. Now the law does require, or the bill does require you to report breaches to the authority in certain scenarios to the data subjects as well, right? But again, and that is primarily based on the harm which is caused to the individuals. Now, if the data itself is encrypted, would you still need to report to the authorities? Would you still need to report to the data subjects? Maybe not. In Europe, if you see, as long as the data is well protected and the possibility of harm to the individual is very low, it can be treated as a non-reportable breach as well, right? So again, pet kind of plays a key role in data breach management as well, right? So these are just some examples where pets do find a reference in the data protection bill, some directly, as I said, some indirectly. And with that, I'll take a pause and we can move to the next section. Thanks.
Thank you both speakers for that incredibly nuanced take on the question. Nikhil, so you mentioned in your opening remarks about account aggregator frameworks, right? And I was wondering some of its potential role in streamlining data collection and consent management and how it could be utilized. If you could talk about that a little bit.
Sure. So I think, look, I think the way in which typically consent is being managed right now is that there is always a collection point of data from the end consumer. So I'm largely looking at a B2C scenario where there is a business which is provided to an end customer. And typically, there's always a typical collection point. You click on a checkbox and then you collect the data. But what the bill proposes is a fairly elaborate notice and consent framework for collection of data. For instance, if you look at it, there are close to around 15 points that you need to specifically tell the user about, including where you store, whether you plan to take the data outside India, right? That's a level of notice that you need to take before you collect the data. Second is you also need to ensure that some of these, if the data collected is sensitive personal information, you need to also provide a granular consent taking mechanism. For instance, you need to have a, click both separately. For instance, you're collecting the biometrics and, genetics of a person. You need to provide separate consent framework for each of these items collected, right? That's a level of detail that the data protection bill wants you to give consent. And that consent should be specific. It should be informing the party about it. So there are two issues that comes up. One is about the number of consents that you need to collect to process data. Second is about the question of amount of compliance and the interference in UI UX that you will have when you come out with a product. right? And as you know, any sort of new tick boxes, any sort of new additions to the whole consent collection framework is hated by the product teams or tech teams when you work with them, right? So I think consent manager is designed or sort of imagined to make this fairly easy and look at existing repositories of information that lies elsewhere in the ecosystem. And for that matter, as you know, all of our information is lying in different repositories across the globe, some of which we have no clue about where it is lying currently, right? For instance, I keep worrying about all the on the internet from maybe 1999 when I got onto the internet to around 2010 when I started becoming aware of the concept of privacy, right? That I used to just freely give away information everywhere, and some of these companies got acquired. I mean, I don't know where these information currently lies. So it's scattered all over. So what consent manager will do for that matter is that one, it will make the life of these product companies which release the products easier, in the sense that look at existing repositories whereby we can pull this information without necessarily going to the user and getting their consent all the time. And secondly, I think it empowers a user to a large extent, a data subject or a data principal to a large extent, in the sense that, for instance, assume that I've been on the Apple ecosystem for over 15 years, but let's say that I want to move to Android. There's a lot of intelligence there is a lot of profiling that has happened over the years. Is there a way in which I can transport all my data from one company to the other without necessarily losing out many of the learnings that the company would have gained on me? I'm sure that some learnings would go because infer data and other things which could be provided to the company. But what a sort of a method like a consent manager does is that it enables this transfer of this data, this portability of this data. Withdrawal of consent, let's say I'm really unhappy with a way in which a company is dealing with my data. So I think that's where I think this is a real win-win for that matter for both the industry and also for the end user, in the sense that it gives a lot of it gives me real agency when it comes to the data. It will also give me the real agency to figure out where all my data is lying and what sort of data is being collected over the years. If you look at, I also have certain information rights under the bill, including to figure out what sort of information is collected about me, including knowing what sort of inferred data is being collected on me. So, so once this consent manager framework comes out, and once it is being plugged into the various other products that exist in the market currently, I believe this is going to be significantly being plugged into what's known as a significant data fiduciaries networks, and that's when it will achieve real value and real purpose, so that one can go and verify what information lies where. I can withdraw consent, I can give consent, I can port data, I can easily move and manage my digital life in a much better, meaningful, effective manner, rather than just rely on the way in which some of these companies offer currently their privacy management tools, right? So I think the other thing it'll also do, and which is also significant for that matter, is it's actually creation of a new industry per se around privacy enhancing technology like consent manager, and the ability for me to even find out who manages my consent in the best possible manner, because there are a few other privacy enhancing, not technology but frameworks, which is suggested by the DP bill, for instance, data trust scores, right? So I think consent managers and data trust scores for that matter will empower me as a user to find out which is a company which is best equipped with their practices and procedures to store and process my data, and which is a company I can trust with respect to the data, which will enable a very meaningful conversation and competition for that matter when it comes to privacy use cases. And that's where I believe the future is going to be. It's exciting because over the last 20 years of my digital life, or 22, 23 years of my digital life, I've often felt quite disempowered as an ordinary user, despite the fact that I've been involved with several companies, in making, and forming their privacy policies and practices. This will truly have the possibility of empowering an ordinary citizen when it comes to their digital life.
Sure, absolutely. No, and talking of companies that are able to get into the market of privacy enhancing technologies, for example, through consent managers, I was also wondering, are there other compliances that can be met within the potential of the bill through new technologies being introduced? For example, can localization or data portability and things like that be given a technological hand to help with compliance?
Yeah, I mean, I would say that yes. I mean, look, from my experience, I would say that look, it's not just lawyers and cybersecurity experts and data scientists who are keenly looking at the data protection bill. It's actually the industry as well, because I think it opens up a lot of possibilities with respect to creating a new market for privacy enhancing technologies. You already mentioned about consent managers. It's a new market that's going to be opened up. There's going to be tremendous potential, and probably the companies which are already in the account aggregator framework will already have a stack which is running for them. They just need to scale it to ensure that they support this new requirement as well. Though that's limited. I mean, account aggregator functions are limited for that matter. Here it's sort of endless the way I look at it, and there could be different sorts of consent managers for different different sectors itself. Like one could work very well for social media, where some other could work very well for some other technology for that matter. So I think that's a interesting area that's going to develop. And localization specifically, I've always thought about it, right? I mean, wherever there is a question about localization, it's always a question of, look, is there a possibility? For instance, 99% of the apps that you see on an app store are really small companies who may not have the ability to actually collocate their data in an Indian data center, right? So there is an opportunity to create localization as a service, right? And give that as a plug and play product. I mean, this could be done by the bigger players like maybe a Google and Apple, who along with their app store. It could be a third-party service which could be provided from the outside as well. So I think that opportunity exists, and I believe someone was mentioning the other day that look, there are few products which are out there in the market who are already started marketing along those lines. The other one, of course, is you will see more and more platforms coming up with respect to privacy law compliance, and whether it's with respect to data portability and just the ability to data map and do the data map within the organization, map your data resources at the right time and allocate the right person who can take call with respect to particular data, ensure they have the right access rights, etc., etc. It's going to be a lot of interesting new technologies that you will see, and I believe that the privacy enhancing technologies is going to be a very interesting market in the coming few years.
Absolutely. And speaking of industry, Nitin, given your background and expertise, what do you think are some of the interesting considerations for organizations while they adopt PETs? And especially, let's look at like sectoral nuance as well, right? So let's say, for example, when they adopt these technological deployments, what are some of the considerations, let's say, for the pharma sector, or the life sciences sector? If you could speak a little bit about that.
Yeah, thanks, Anisha. I think if I look at it from the larger perspective of pets, which I talked about, right? Encryption, I think we all know that it has been used, or it is being used in the industry, including the pharma and the life sciences kind of sector for a fairly long time, because life sciences sector does deal with a lot of sensitive data, primarily health information and biometrics and so on and so forth. But if you look at the other technologies, which I briefly talked about when I gave my initial remarks, they are fairly in a nascent stage, I would say. They have yet to reach the level of maturity which would be required to have for large-scale adoption of those technologies. But there's a lot of work being done because of the potential of these technologies to kind of support the requirements which the life sciences sector has. I'll talk about that in a minute. I think I was doing some research on adoption rates, basically, and what Gartner has estimated, and these numbers are, I think, from 2020, if I'm not mistaken, that right now there are some 1% or 2% of companies which are looking at using these kind of pets, but by 2025 they expect around 20% of companies to have some kind of a budget for doing this. In India, I think with the introduction of the data protection bill, I think the push for adopting these kind of technologies would be a lot more, including in the life sciences sector as well, which would help them to kind of share data in a more responsible way, collaborate more with third parties and so on and so forth. But I think the main point which I would say is important when it comes to adoption is identifying the use cases. Just because there is a technology out there or a new toy out there in the market doesn't mean that it's going to fit within your company architecture as such. So the main point there would be to actually identify use cases where find out where business really has problems, right, which they are not able to solve with existing technologies. Identify those use cases and see if one of these pets can fulfill the requirement over there. Start maybe with a small pilot. Uh, Show success from that, and then you can move on from there, right? But it shouldn't be that there is a technology and you want to force fit it, but there should be a use case for that, and then you try to understand which technology is going to help you do that, right? So that's more from the adoption perspective, I would say. When it comes to the life sciences sector or the healthcare sector overall, right? As I said, we all know that it deals with a lot of sensitive personal data. Healthcare traditionally, at least from what I've seen, has been slow to adopt technology for various reasons. As I said, they do handle a lot of sensitive data, the amount of harm which can be caused to a patient, and this harm can be material or non-material harm. It can be mental, physical, financial kind of harm to the patient. If the data is misused, is a lot, right? And that is something which is not reversible as well. In the finance industry, for example, if you lose your credit card, you can always replace that with a new credit card with a new credit card number, but you are stuck with your health information for most of your life. It's very difficult to change your health information, right? So healthcare has that nuance where it's very critical that the data is safeguarded well. It is the privacy of the individuals is managed well, and so that's where healthcare kind of has been slow in terms of adopting technology, but we are seeing that change over the last few years. They are more open to collaborations, not just using third parties, but more collaborations with other healthcare services industry. And so that's where it is increasing quite a lot. Uh, Sharing data is critical for the healthcare industry, and that's one of the things that we all realized during this pandemic situation as well, where the data about the COVID virus itself, how the pandemic spread in the various countries, it was essential to be shared with the healthcare industry. One of the key reasons why we, as a overall industry, were able to develop the vaccines in less than a year or around a year was because of the data sharing which was enabled within the industry as such, right? So there are possibilities in terms of using pets to ensure that we are able to use data in responsible ways. A couple of examples which I can give where this would be really useful, and this is slightly forward looking, but very much possible in the very near future, I would say. Uh, Real world cancer data, right? So in cancer, not all cancers are treatable as of now, right? But what happens in the real world is that doctors, depending on the situation of the patient, they sometimes prescribe existing cancer treatments for what is called as off-label use, right? So one cancer treatment can be tried on another cancer patient because there is no other treatment available for that other kind of a rare cancer. If you look at it now, this data is not generally available, and that by the time this data is gathered from various countries and shared with the pharma companies which have developed this medicine, it takes years, sometimes decades as well, right? So patients who have this kind of rare cancers, it's difficult for them to get this treatment which might be working, right? And using some of these pets which I talked about federated learning or encryption, basically, it is possible to share this data in a more in a better way, I would say, and allow this treatment to reach those patients earlier. Another example is where for clinical trials, the more number of participants you have, the better it is for the clinical trials in terms of efficacy and safety. Now, patients generally are kind of apprehensive when they want to share their health information, even if it is to see if they qualify for a clinical trial, right? Now, again, this is where pets can come in handy, for example, and they can help the patient share their data, maybe in an encrypted format. The data is processed. Uh, it is without the third party or the site being able to see what the data is, they're able to determine if the patient is a good fit or not, right? So these are like simple use cases where pets can enable much better use of data, especially sensitive data in the healthcare industry, and hopefully this will pick up speed in the near future as well.
Absolutely. And again, just in the context of pets, I was also wondering maybe what role do pets play with respect to data transfers? And what I mean by that is what kind of technical guarantees can pets provide uh, in terms of data transfer security, especially post the Schrems 2 judgment? So if you could throw some light on that.
Yeah, yeah. So thanks for that, Anish. I think I briefly talked about Schrems when I talked about the cross-border transfers, and it is, as I said, the talk of the town right now. So very briefly to look into the history of what Schrems 2 is, right? So so this primarily came up in terms of the transfers between or from EU to the US, but some of these concepts are applicable to transfers of data from within EU to outside EU generally, right? For example, to India as well. Mostly, at least when it comes to EU to US transfers, there have been some kind of frameworks which were used, self-regulatory frameworks to a large extent. The first one was Safe Harbor, the next one was Privacy Shield. Uh, and the whole crux of the matter when it comes to cross-border transfers basically is, does the importing company offer the data subject, the individual in this case, enforceable rights and legal remedies, right? So if the data is sent, let's say from EU to US, and the data is somehow misused in the US, does the individual have these rights, the privacy rights especially, and the remedies to kind of enforce his or her rights, right? So that's the whole crux of the matter over here. Uh, and to this effect, Max Schrems, who is a privacy lawyer and an activist, so he had filed a case against Facebook few years back, and it went right up the chain to the apex court in EU, and the apex court finally ruled that both Safe Harbor as part of Schrems 1 and Privacy Shield as part of Schrems 2 judgment were invalidated, right? Now, it doesn't mean that all the transfers have stopped. There are other mechanisms such as standard contractual clauses. There are other mechanisms called as binding corporate rules, BCRs, which can still be used both for transfers within the organization and to third parties as well. So in fact, there was an interesting comment from Daniel Soloway, who is again a prominent privacy practitioner. He mentioned that the Privacy Shield is dead, and both the SECs and BCRs are in coma, and on life support as well, which to some extent is true, I would say, because though the SECs were not invalidated, what the court said is that they had to be kind of supplemented by having additional measures in place. And one of the key measures which has come up, right, is encryption, right? So encryption while the data is being transferred, and encryption when the data is stored at rest as well in the US, right? So when it is being transferred, one of the risks which has been identified is that the US government can force the communication service providers to tap the transcontinental lines as it is, and share that data with the US government when they want to have access to that data, right? And encryption is one way in which this kind of risk can be avoided, because if they get the encrypted data, there's not much they can do with it without having the decryption key as well. Once the data reaches the US, again, it is something which again, if the government asks for the data is going to be encrypted. And again, encryption is going to play a key role when it comes to safeguarding that. So I think when it comes to cross-border transfers, especially when it comes to Schrems, and the impacts are going to be not just for transfer of data from EU to the US. I think they are there for EU to the whole world, I would say, right? Because SCCs are used pretty much everywhere, right? So that's basically the background behind it. And as I said, encryption is one of the key ways in which it is thought that it can prevent some of the risks which come up when it comes to data access by the US government and potentially by other governments as well. Now, it is still not clear whether the governments can demand the encryption key itself. That is not called out clearly anywhere, I would say. It is still not clear, but at least it has been looked upon as one of the key ways in which the cross-border transfers can be continued, right? If you really look at it, look at GDPR, the two key objectives of GDPR, one is of course to protect the rights and freedoms of the individuals, including their privacy right, but also to allow for flow of data, of personal data, right? And we are at a situation where this flow of personal data is getting hampered to a certain extent because of frameworks not being in place, because of surveillance laws which are strong enough to kind of negate some of these protection which the laws provide, right? So I think we are at a very, I would say, delicate situation. Very recently, there was this case in the last couple of weeks where I believe the Austrian Data Protection Authority, and recently, I think this week, France or the French Data Protection Authority, they invalidated or said that the use of Google Analytics is not compliant or in compliance with the GDPR, mainly because again the personal data is transferred to the US in most of the cases, right? So there's a lot of attention, I would say, on cross-border transfers. How it will get impacted, I think we'll have to keep a close watch, understand what are the ways to kind of circumvent some of these challenges which are coming up with use of SECs and BCRs as well. But yeah, I think it's an interesting time to keep a tab of this and figure out ways to overcome some of the challenges that we have.
Absolutely. And I want to ask more questions, but we have a whole host of questions that's come in from the audience. So I'm going to not waste any more time and jump right in. Nikhil, this question is directed to you. How do you look into the differences or similarities between the Data Protection Bill 2021 and the EU's GDPR, especially in the context of pets and encryption and such technologies?
So I think to be very frank, I think our DP bill is actually much more forward-looking than the GDPR is when it comes to privacy enhancing technology. So I think, for instance, the consent manager one is probably one of the greatest examples that I can cite, because it's a brand new subject, right? In itself, that it goes on to the level of recognizing a new form of PET per se. Secondly, I think, look, I think to that extent, I mean, it's not really a privacy enhancing tech, but it's basically a measure like, localization itself. What the government is proposing is that it's proposing it as a privacy enhancing measure per se to prevent, trans-border surveillance of information of our citizens per se. And in several ways, I think the best part that I can think about the Indian DP bill is the fact that it talks about, it gives the flexibility to similar to the GDPR in terms of coming up with security measures to ensure that the cross-border transfer of, or even for that matter, any transfer per se, whether it's your outsourcing service provider, etc., to a data processor per se, needs to be preserved by way of a secure mechanism using re-identification or other privacy enhancing technologies per se. So one additional point, Anisha, if you could let me, I mean, also just to add on to what Nitin is saying, right? So I think one thing, if the best thing about, or the good thing about Shrems is the fact that the Shrems have recognized the fact that, look, apart from just looking at equivalence on other things, there are various things that you need to do. For instance, you need to do where your data is. You need to plan for, depending on where your data is, which jurisdiction it is. You should have some idea about the fact where the data is residing, etc. One fault of FREMS per se is the fact that, look, it asks for equivalence, right? And when you ask for equivalence, the problem is that you can only compare, it's like comparing apples to oranges, right? I mean, it's going to finally, it's two different fruits with two different flavors. It's never really possible to compare. For instance, I think one of the biggest problems with Shrems, for that matter, to my mind, is the fact that they're looking at data transfer to India. I mean, it's true that we have quite extraordinary, surveillance provisions in India, similar to like America, except the fact that we don't have a FISA code equivalent. It's a country with very strong surveillance regime. But having said that, in practice, that surveillance is not really applicable to, the government is not really after the EU residents' data per se, right? So in that sense, I think the equivalent standard that's prescribed by Shrems is quite missing, right? And that's something that we should look at when we look at data transfer per se. And when organizations weigh in and figure out if there is a risk to data transfer to India, I think that's a factor that they should keep in mind before they take a decision. Just adding on that, I know that's got nothing to do with PET.
Absolutely. And Nitin, this is a question that's coming for you. Is homomorphic encryption efficient enough for real-world use? If not, what is the timeline for this?
Yeah, so from what I've read about homomorphic encryption, it is several magnitudes of in terms of efficiency, it is several magnitudes less than the current processing powers that we have, right? So that's where I said that these technologies are still developing. They have not matured yet. But that level of magnitude has come down quite a lot in the last few years because of the research which has been going on. I don't think it is still full market ready, if I can call it that. There are use cases where it is being used, but the amount of data which needs to be processed there is a lot lesser as compared to what we would expect it to be normally used for, right? So that's where it is right now. So I think there's still room for maturity to come in over there. In terms of timelines, to be frank, I'm not very sure. I think they started getting developed, I think in the 2010s, if I'm not mistaken. So around 10 years, it's been 10 years in the making or so. If you look at encryption, it took 30, 40 years for it to fully mature and come to reach to the level of maturity. I don't expect it to take so long for homomorphic encryption also to kind of become mainstream, if I can call it that. But I think it will take another few years for it to be as efficient as it is for processing like normal data, right? I don't have an exact timeline, but maybe another few years for it to become mainstream as such, but still some way to go, I would say, to become mainstream over there.
Still forward looking.
Yeah.
Nikhil, the question here, the biggest gap in the bill is the lack of privacy regulation for paper to digital shift of records and data. How can privacy be protected in the migration case?
Sorry, can you just repeat the question? Are you saying that paper to
Yeah. So the biggest gap in the bill is the lack of privacy regulation for paper to digital, that shift between records. How can privacy be protected in the migration case?
So so the way that I look at it, I sort of disagree with that statement. I think this bill will apply to even paper records for that matter, except the fact that there was actually a manual processing exemption for entities and organizations within a limited scale. I think there's a 200 number or some sort of a limit given there. Other than that, to my mind, I think this applies to even paper as well, which is actually not the case if you look at the IT Act and the Section 43 rules under the IT Act. It did not apply. It only applied to electronic record because of the fact that it was clearly under the Information Technology Act, and it only looked at electronic records or data for that matter. So I believe that it will apply to any sort of processing because technically even digitization of existing records, this bill should apply to any sort of processing that's been done, even for collection of data, even on real life terms for that matter. We know that several government data gets collected in such manner in paper records. The bill will apply to those sort of collections as well, in my opinion. That's the way that I've been reading the bill.
Okay.
Yeah, Anisha, if I can just add to that point, if you don't mind, because it's an interesting point, and though it may not be explicitly called out, just like Nikhil said, right, I would still treat data as data, right, whether it is in a digital format or in a paper format. I'm sure there is a lot of data out there, personal data out there on files in forms which has been filled in either as part of like HR records, for example, or in hospitals where you have to fill out forms and share your health information, for example, right? So there is a lot of data out there, and just because it happens to be in a physical format doesn't mean that it should not enjoy the protection of the law. At the end of the day, the privacy of the individual is still going to be important, right? Whether the data is misused when it is in physical format or in digital format, I would still look at it exactly like what Nikhil said, right? It still applies. Do take care of it. Make sure that you have the required safeguards and controls in place.
Yeah, and also, Anisha, just to add to it, I think it's very evident from the way in which even the word processing is defined. Right? So it's not limited to an electronic processing per se. It's basically any sort of recording, any sort of collection will actually extend to, it will just cover all forms of data.
Nikhil, I think there might be some disturbance in your audio. We can't hear your last sentence.
Can you hear me now? Are you able to hear me now?
A disturbance. We can hear you, but there's a disturbance in your.
Is it better?
No.
I think there is some scrambled kind of sound, Nikhil.
Okay, just is it better now?
Nikhil, can we request you to log in again to the platform? That might just hit the yeah. Go ahead, Anisha. Yeah.
All right. In the meantime, I'm going to move on to a question. What do you think is the current readiness of the healthcare industry to take on the demands of the DPP?
I think from a healthcare industry perspective, some of the facts which are, I mean, some of the aspects which are required from a compliance perspective, right, are there. A lot of them come from a sectoral perspective as well. So, for example, when you collect data either in a clinic or as part of clinical trials or as part of other aspects, right? The fact that there are sectoral requirements, the fact that there is IT Act requirement which requires it to still take consent. I think those aspects are there in some form or shape, I would say. I mean, practically also when we go to hospital, the hospital does ask you to sign forms, ask to give your consent and so on and so forth, right? So I would say some aspects are there, but I think there would be some upgradation required. For example, we talked about the fact that the notice requirements in the data protection bill are fairly heavy, right? I mean, there are, I think Nikhil pointed out some 14 or 15 points which need to be covered as part of the notice, which would require some kind of change in the consent forms that we would have developed, for example, right? But one of the things which I see as a gap, so I mean, just to point out that yes, there is some readiness out there, some upgradation which would be required, some upskilling which would need to be required. But I think one of the main things which would be required is from an overall compliance perspective is to ensure that not just healthcare, but I mean all industries basically need to have that record of the processing that they carry out when it comes to processing of personal data. Very few companies that I have talked to so far, at least as part of my interaction with peers in the industry, have that kind of a record of processing. And unless you know what processing you're having in your organization, it's very difficult to kind of comply with the law, right? Because you might have processes in place to comply for 5 of your business processes, but what about the rest which you don't know about, right? So I think the key starting point for healthcare and for other industries also is to ensure that you really have a good understanding of what kind of processing you carry out in your organization. Start work on that, gather that inventory, and then start ensuring that you have things in place for compliance with the law. But I think that would be a good starting point as such.
Okay. Sounds good. Nikhil, I just have a quick question for you, which is, do you think PETs within the scope of the bill will be an enhancer or a restrictor for data flows generally across the board?
So I believe it will be an enhancer. I believe it will be an enhancer for data flows and overall data sharing per se. Because I think PETs, by employing more and more PETs, and some of them that we looked at, what Nitin just went through, including k-anonymization and differential privacy and various other PETs, and encryption, of course, which tops the list. It is going to ensure that one, you could share data with confidence, you could share data with adequate belief that look, you're not exposing yourself to liability. It will also give more confidence in those those data principals who are actually giving the data to you, that even though the organization that I've given this data to sharing the data, it's actually taking the adequate precautions. It's employed privacy by design and data protection by design principles to protect my right to privacy. So to that extent, I think it'll have a very positive impact on data sharing per se. But having said that, initially, for some period of time, when we have this bill in its infancy, we will see that some of the ways in which business is carried out currently. I think Nitin just mentioned about the way in which the health sector probably is not really ready to sort of implement the bill per se. We will see that in certain sectors or certain sections of the society, some may find the compliance a bit too much, too difficult and too onerous. Two aspects to keep in mind. One is, I think we are looking at scale. Once this industry develops, the PET industry in India develops, it's already at this nascent stage. Once that happens, some of these products and offerings will start becoming cheaper. Then, of course, it will take some time for several sectors. The non-digital sectors per se will take some time to comply with the provisions of the bill, because they will also take it lax that the enforcement may not come to them. By that point of time, I think we'll be in a good state, and the overall cost of compliance in the long run will definitely come down, and that will have a very positive outcome to sort of the digital revolution that our country is undergoing at this point of time.
Absolutely. And actually segueing from that question, there have been quite a few questions around what is a good global certification for cryptography or for encryption tools or for PETs at large. If there is a certification of some kind, this is a question that's been repeatedly asked by the audience. Is there a certification, or is there something that's adjacent to that protocol?
So is the question certification for these PETs or encryption technologies, or sorry, maybe I didn't understand that question quite well.
They've asked for everything. They've asked for, are there global certifications for PETs? Are there global certifications for encryption technologies? So generally across the board.
I mean, I can try to share my views, and Nikhil, if you have something to add, please pitch in. But as far as I'm aware, I don't know if there are certifications for these technologies per se. I mean, as we said, most of these technologies are developed over time. They undergo rigorous kind of reviews by peers, by the industry, right? Encryption itself, the fact that it has to be kind of recommended by the industry bodies, for example, like NIST, they do have to go a lot of rigorous testing by the industry at large before they are kind of declared to be fit for use. Right? But it's not like somebody certifying those as such, but it's just through rigorous testing that somebody like NIST will come and say, hey, now you can use this technology for, let's say, asymmetric encryption, right? So that is the way it generally works, and I'm sure that is how it will work for the PETs as well. So it is more of testing by the industry, by the various bodies which are involved, which will help to kind of mark it as viable for use by the larger industry. But I'm not aware of any certifications as such for PET specifically, at least.
Sure. Another question that's been repeated a couple of times is, how is biometric data protected in the bill, and how does government identify gaps in various products and services with respect to the point specified in the bill with the larger context of biometric data? It's an open question. I will. Yeah.
Sure. So I think a couple of aspects. So one, I think if you're processing biometric data, you can only do it as per what's stipulated by the government. So there is a bar on processing biometric data, unless it's allowed by the government specifically, right? So that's going to cause some issues in the beginning itself, and you expect the DPA to come out and say that, look, the biometric unlocks on the phones and other devices, and similarly biometric attendance management systems, and of course Aadhaar for that matter, the other use per se, are all specifically allowed. That's the way in which biometric data processing has been handled. And secondly, if you're processing biometrics data or genetics data, I mean, that's another one important from a health sector perspective, then you could be classified as a significant data fiduciary, and you are subjected to several compliances which are quite onerous in relation to data lifecycle management with respect to data processing and operations, and you need to appoint a DPO in India, and various other compliances will apply to you if you process these two kinds of data. And biometrics, I think few things to keep in mind. I think facial recognition is going to be quite key. It will be very interesting to see how the DPA will classify such users. There could be different checks and balances, and I think PET will have a great role to play. I mean, this is something that I did not get into earlier. For instance, something like what Apple does. I mean, the non-storage of biometric data in their centralized system. I mean, very similar to maybe the federated processing that Nitin spoke about, right? It's actually federated processing which unlocks your phone, and it's not getting stored within the Apple central database. Is a good way to probably get a biometric or a facial recognition system allowed. For instance, similarly, you have smart fridges and smart appliances which can recognize the owner. The question is there a need for it to relate back to a centralized database, or can the processing happen and be harmonized at the collection point itself after the purpose of collection is done?
Your voice is breaking up again.
Yes, again breaking up. I'm sorry. Oh, what's happening?
No worries, no worries. It's all right. Yeah, so I think one last question, and this question is not directly related to PETs, I will agree, but this is a question that keeps coming up again and again. how does emerging technologies like blockchain, Web3, metaverse, etc., how will it be accommodated within the data protection bill? Again, it's an open question, either one of you.
Sorry, Anisha, can you repeat that? Actually, your voice was kind of breaking now, unless I'm the one who is having issues on my side, but I couldn't hear the question actually.
Am I audible now? Is it better?
I think so.
Yes,
Yeah.
Nikhil, I'm so sorry, but can you re-log in again? I guess there is some audio disturbance at your end.
Is it better now?
There is some cracking that is happening in the background, but if I may request, if you can just log in another second. Meanwhile, Nitin can answer this question.
Good.
Yeah, thank you, sir. Go ahead, Anisha.
All right. Is there a disturbance on my end?
No, I think it's okay now. No, go ahead, please.
Okay. Yes. How does emerging technologies like blockchain, Web3, and metaverse, how are they accommodated within the bill? I agree it's not directly tied to PETs, but this is a repeated question, and I thought, given the speakers, we might as well address it.
Yeah, so I think the way I look at it, Anisha, and sorry, I didn't get the person's name who asked this question, but the way I look at it is that, I mean, technologies will keep coming up, right? I mean, we have metaverse, we have blockchain, but I think the way our principles, the data privacy principles which are listed in the bill are going to be applied, they are still going to apply as long as there is personal data processing to be involved. They are still going to apply. So principles of minimization, principles of purpose limitation, giving a notice, right? All those requirements, retention of data, and so on and so forth. So all those requirements are still going to be going to apply for whichever technology comes up in the future as well. And that's one of the reasons why the data protection bills, including starting with GDPR, are kind of technology agnostic, right? So when blockchain came up, there were several challenges which, especially with respect to, for example, maintaining the integrity of data, editing data on the blockchain, for example, how do you take care of data retention and disposal on the blockchain, right? So all these challenges came up. I think the industry is working on solutions for those. I think that will continue happening, right? So when metaverse comes up and starts becoming more and more popular, I think we will need to figure out those things for metaverse as well, right? So my take is that yes, technologies will keep coming up, new areas will keep developing, but I think the way we apply these same principles to those technologies is going to be important. Those are not going to change at all, at least for the time being, right? And how we apply them and how we put in the right set of measures and controls to still take care of the privacy of the individual is what is important. So I would look at it more as a technology agnostic kind of data protection bill with the same principles applying for whatever new technologies come up.
Absolutely. Thanks, Nitin. I also wanted to know Nikhil's observations on the topic. I will quickly repeat the question in case you. How do you think the DPB accommodates for newer emerging technologies? Let's say blockchain, Web3, metaverse, etc. So how are accommodations made for such provisions within the bill?
So I think it sort of is technology agnostic in its operations, but there are a few areas where it may need to just, we may need to just take a step back and start thinking about some of those things. For instance, I think one of the key aspects is with respect to the ambient data collection that happens with IoT devices, right? So we are still at we are at 1.0 when it comes to IoT, right? When we move to a 2.0 or a 3.0 scenario where there is going to be collection, and for that matter, indiscriminate collection of information from every side, which involves ambient data collection as well. So for instance, when the Alexa is in my room or any other product is in my room, and there could be my neighbor coming in and speaking, and his voice gets picked up, and that's, is that biometric information? Then there are sort of all sorts of questions that the bill doesn't really account for. So to that extent, and there are questions about, look, what is the notice that's possibly given to that person, right? Even the very fact that a device like this, which could record the information, by context, can it be interpreted as a notice given to that person, right? To my mind, yes. I mean, to an average person who looks at a device, or similarly who looks at a CCTV camera, do we need the 15-point notice that needs to be given? And to that extent, I think you will see the principles and jurisprudence around the bill evolving. It is like Nitin said, it's designed as an agnostic piece of legislation, but probably the interpretation level, the TA will also need to take a very practical call to enable some of these newer technologies from being developed and implemented, and that obviously shouldn't be hindered because of the fact that we have a bill which is strict otherwise.
Absolutely. Thank you to both our speakers. I'm so sorry we're running out of time. That's why I can't take questions. I apologize to the audience that have sent in the rest of the questions closer to the end of the session. Again, thank you to our incredible speakers, Nitin and Nikhil, for joining us this day and for gracing us with your presence at the first CIPHER Seminar Series. And to all those who tuned in, thank you. Please do tune back in for the next CIPHER Seminar Series. Thank you and have a wonderful evening. Thanks, everyone.
Thank you. Thank you, Anisha. Thank you, DSCI.
Thanks, DSCI. Thank you.
Thank you.
Bye.